There is a further issue, which is after Mr. Carrim wasn't available to testify at his last appearance and is now, well, after he wasn't available to testify at his last appearance, we asked that Mr. Carrim make himself available for examination by a specialist appointed by the Commission to confirm that he was indeed not medically fit to testify. And he hasn't yet responded or hasn't yet complied with that request. So we sit in a situation today where this is the second appearance for which Mr. Carrim has been medically unfit to appear. We're running out of time. And there are a whole succession of details and documents which he undertook in evidence to make available, which were then demanded of him in terms of notices and which have not yet been forthcoming. So we accept that he is not available to testify today, and that he has been admitted to hospital. So we can't have him here today. But what we would ask of the Commission is to postpone his appearance to the 15th of July. And our request, or our intention in relation to what will happen on 15 July is, obviously, if Mr. Carrim is here, he will be questioned. It will be the end of his testimony. If he is not here and is still on his version medically unfit, we will no longer seek his appearance on the 15th of July. But if he has subjected himself to independent examination by a specialist appointed by the Commission, and that independent specialist confirms his incapacity to testify, we won't ask for him to be called again. We won't have time to hear his evidence, but we will ask the Commission to make its findings in relation to all matters relevant to the evidence of Mr. Carrim on the basis of the evidence that he has already given and on the basis of the evidence that he has thus far not answered, and his failure, if the failure still persists, to furnish audited financial statements, details of auditors, and the like. If Mr. Carrim does not agree to be examined by an independent specialist, then we will ask the Commission to recommend that he be prosecuted under Section 5 and 6 of the Commissions Act and Regulation 12(2) for hindering the proceedings of the Commission. And we will also ask for the Commission to make its findings on the basis of the evidence that we've heard thus far from Mr. Carrim, but no further evidence.
Regarding that proposed criminal process, I would imagine that the mental element would consist of intent. And are you basically saying that's something that would then have to be investigated down the line?
It would have to be investigated. I don't want to address argument on that, because I'm still hoping that one of two things will happen. Either Mr. Carrim will have recovered and will be here in 3 weeks' time, or his medical state will have been confirmed.
So that's an issue.
So it may never arise, but I want to give notice now that the Commission, or the evidence leaders at any rate, I can't speak for the Commission, the evidence leaders are taking this very seriously, because we regrettably are of the view that thus far we have not received the necessary cooperation.
I guess at this stage I'm going no further than just raising this so as to start thinking about it. No
Indeed,
further.
I'm not asking the
further.
Commission to
No
make
further.
any decisions at this stage, but I do need to place it on record so that Mr. Carrim and his legal team know where we will be going.
Okay, all right. Please continue.
So for present purposes, all that we would ask from the Commission is a postponement to 15 July. That's all I have to say at this stage.
Thank you, Mr. Chaskalson. Yes, Mr. Premhead.
Thank you, Chair. Good morning. Three very brief submissions in response to what my learned friend has said. The first one on the documents and the alleged non-compliance. My learned friend made reference to three dates, 8th May, 12th May, and 20th May, when the relevant instruments requiring those documents were delivered to Mr. Carrim. I would just point out that as far back as the 14th of April, 2026, in response to the Commission's letter on the 14th of April, 2026, at page 3, paragraph 11 of that letter, Mr. Carrim's legal representative said the following after Mr. Carrim's initial hospitalization. We further advise that we as the legal team are dependent on Mr. Carrim's family to receive updates regarding Mr. Carrim's condition, which depends on the medical treatment and advice he is presently receiving. We will update you as appropriate when we receive the information from Mr. Carrim's family. Now, I highlight that only to point out one thing, and that is when Mr. Carrim was initially hospitalized, it was explicitly stated to the Commission that the legal team, as creatures of instruction, cannot act without instructions from their client. And if their client is medically indisposed, particularly in circumstances where his medical indisposition started ahead of May, it started in April, it stands to reason that this allegation of not complying must be put in its proper context, that it's not willful, and it's because the ability to deliver those documents is directly hamstrung as a result of Mr. Carrim's medical condition and all the subsequent correspondence and all the subsequent medical reports, of which there have been 4 reports, which make it abundantly clear that Mr. Carrim is not only able to attend the Commission, he's also not fully able to engage with his own legal team regarding his ability to give instructions. So that's the first point I want to make, Chair. The second point I want to make, Chair, is in respect of this independent medical examination request that has been now raised on the record by my learned friend.
But which I understand was raised previously. But
yes.
Of course, I do hear you say on record.
Yes.
But as a matter of fact, it was raised through correspondence.
I don't take any issue that this is my first occasion of having notice of that.
Yes, all right.
I just want to address the reference. Excuse me, I just want to address what my learned friend said, Chair, in the context of raising it today. The Commission sent our client and his legal team a letter yesterday on the 24th of June where this was raised, and I'm not sure if my learned friend or the Commission itself have seen our response to that letter, also dated the 24th of June. The only thing I want to emphasize from that 24th of June letter, Chair, is what is...
Sir, before you go on, are you saying that the possibility of subjecting Mr. Carrim to an examination by a specialist of the Commission's choice was raised for the first time in yesterday's communication?
No, I'm not saying that.
Yeah, I'm asking that so that it does not appear to all concerned that's what you are saying.
I'm only addressing the content of the letter of yesterday as it responds to the letter of yesterday from the Commission, which I understand my learned friend to be foreshadowing with you today.
I understand you, but I just want the fuller picture out there. It was not the first time yesterday.
Unequivocally, I say on the record it was not raised yesterday for the first time in the correspondence. It had been raised prior, and the parties have been engaging on that. I'm just limiting it to the to the exchange yesterday and as it comes in front of you today.
Yes.
All I want to say, Chair, is that in respect of that contention or submission that is an available avenue to the Commission, in our letter of yesterday, particularly paragraph 10, you would see that certain issues were raised, and those issues were raised with the purpose of saying, and I place this on the record as well, is that once that is clarified, our client can then be informed of what the position of the Commission is, and he can exercise his rights to the extent that he can, and give us instructions to the extent that he can. So,
may I just raise this? In the context of claims arising from, for example, bodily injury, medical malpractice, such examination happen as a matter of course. One of the issues raised in the letter we received, I think, at night, I might be mistaken, is the question whether there is a suspicion that, I'm paraphrasing.
yes,
maybe
I accept.
That Mr. Carrim is not in fact suffering from what is stated by the doctor.
Yes.
Bearing in mind what I've just said about this happening as a matter of course, would you say in those cases it happens because there are suspicions?
No, but may I qualify my answer on the following two propositions?
Yes.
The first one is the regime that the Chair is putting to me is firstly in the context of medical negligence claims or damage from medical negligence, which we know arises under a prescribed procedure under Uniform Rule 36. And related proceedings under Uniform Rule 36, where there's the contestation between parties and the need for independent medical examination to determine the extent of damages claimed and various